Just a minute. Yes.
Sir, I beg to mention item number 7, my lord. This may come off after 2 weeks, my lord.
7.
Item 7, my lord.
Why do you want adjournment?
My lord, it's basically a matter, my lord, will have a my lord, which is pending in the Supreme Court, will have a bearing on this matter, my lord. The Lordship had earlier heard this matter also. So, my lord,
Mr. M. Datta, learned counsel for the petitioners. You're in one case only, no?
one case, my lord.
What about the other side?
Other side, my lord,
Are they agreeable?
government, my lord.
No. The other case which is clubbed together.
Yes, my lord, they, my lord, I will basically, it's my argument, my lord, they are with me, my lord.
Mr. M. Datta, learned counsel for the petitioners in WPC number 2116 of 2022 submits that the issue involved in the present writ petitions are also under consideration of the Honorable Apex Court, and the outcome of the same would have a bearing on these matters. Stop. He therefore submits that since the outcome is awaited, matter may be adjourned for 2 weeks. In view of above, matter stands adjourned for 2 weeks. We'll have a date.
No, date has not been given. That's what I'm told, my lord. Here, my lord.
Yeah.
Lordship can give a date, my lord, after vacation.
Give a date in May.
Month of May, my lord.
List on. You have a chart. How many cases are pending and all that listed? Okay. Give me this. Okay. List on 4th of May.
Deeply obliged.
All right. 30. Mr. A.R. Tahwildar, learned counsel for the Higher Education Department, submits that he has some personal difficulties to conduct the case today and prays for adjournment. Stop. He submits that he has also taken the consent of the learned counsel for the other side. We understand that, but we cannot club together all cases in one day. All right. We'll see the date. We'll see a convenient date. Just a minute. In view of above, list this matter on. Already so many cases are there. They have it on 7th of May. 7th of May, Thursday.
May I please, Your Honor?
Yes.
I beg to mention item number 24, Your Honor, for adjournment, Your Honor. Kindly, this matter may be adjourned and may be fixed 22nd.
These are for orders.
Yes, Your Honor.
Item 24.
Yes, Your Honor.
Let the matter be called. We'll see. As and when it's listed.
The leading counsel is out of Your Honor.
Okay, we'll see. We'll accommodate you, but let the matter be called up. We'll see why is it listed for orders. Yes. Item? Which respondent? Number? Ms. B. Chaudhary, Ms. N. Chaudhary. N. Chaudhary, learned counsel, appearing for respondent numbers 3 and 4. Praised for adjournment on the ground that she is yet to receive instructions for filing counter affidavit.
Kindly, Lordship, fix a date, Lordship, because
She also submits that she has taken the consent of the other side. In view of above, discuss matter. Again on 6th of May.
May please your lordship. I beg to mention item number 5. Finally, adjourn this matter only for today, lordship.
For petitioner,
No, lordship, respondent number 6.
have you informed the other side?
Yes, lordship.
Informed?
Yes, lordship.
Why do you want adjournment?
Lordship.
Why do you want adjournment?
Lordship, Mr. Engaged counsel, Mr. R. Fukan, he is not available in Guwahati, lordship.
Mr. R. Fukan, learned counsel for respondent number 6, is said to be out of station. And a prayer for adjournment has been made on his behalf. Stop. It is submitted that the consent of the other side has also been taken. Stop. In view of above, matter stands adjourned to be listed again on a date to be fixed by the registry. Next.
Lies, lordship.
You take it up with the registry for listing. Okay? I understand. You take it up with the registry. It's a new case. New case. It will come up. What is there? You have filed only yesterday. You have filed only yesterday, so you'll come up in due course. You have some urgency, you should have filed before last week. Next week, you know, is a holiday. On 22nd. Change the date, 22nd.
May it please, your lordship,
Yes.
I beg to mention for adjournment of item number 28.
28.
Due to personal difficulties, engaged counsel A.Y. Chaudhary unable to appear. Kindly fix the next date.
Have you informed the other side?
So,
Hmm? Any objection? Elementary education, 28. All right, Mr. A.Y. Chaudhary, learned counsel for the petitioner, is said to have some personal difficulty to appear before the court today. On a prayer made on his behalf, the matter stands adjourned to be listed again on the date to be fixed by the registry. Yes,
any date after
registry will give a date. Next.
apply.
Please, Lordship, I beg to mention item number 5 for adjournment.
I've already mentioned.
Mentioned.
Yes,
Please, Your Lordship, I seek an adjournment for item number 3 and 4.
yes, you have circulated adjournment slip
Yes,
on behalf of,
on behalf of PD Nair.
okay. Mr. P.D. Nair, learned counsel for the petitioner. Petitioners is said to have some, oh, these are same person. On learned counsel for the petitioner is said to have some personal difficulty to conduct the case today. On a prayer made on his behalf and not opposed to by the other side. Matter stands adjourned. To be listed again on a date to be fixed by the registry.
Hello.
Yes. Yes.
May, may I please, Your
Hmm.
Lordship? My lord, a speaking order, my lord, is under challenge, my lord, and my lordship may be pleased to find the order, my lord. Is
Page,
that the type copy starts from page 73, annexure 13, my lord.
Page?
Page 73, my lord, annexure 13 to my petition.
Yes.
Lord, in fact, this present, my lord, proceeding is the second round of litigation, my lord. Matter pertains to provincialization of service, my lord, of a science graduate teacher in a upper primary school, my lord. My lord, what has happened, my lord, due to the resignation vacancy, my lord, the petitioner was appointed way back in the year 2008, my lord, and which had been duly acknowledged by the department also. But my lord, as in the my lord DIAS data or the DIAS my lord record which are required to be maintained by the school, their allegation is that the name of the petitioner was not found and the name of one Mr. Rafiqul Islam was available, my lord. That's why, my lord, the provincialization aspect of the petitioner has been, my lord, rejected by way of this impugned speaking order, my lord. If my lord may be pleased to take up the, my lord, the factual part is very long, my lord.
Mr.
lord.
Bhuya,
My
we'll
lord.
issue notice today,
Yes,
right?
yes, my lord. Yes,
We cannot complete the hearing and
yes, yes, my lord.
pass judgment like
My
that.
lord.
So we'll issue notice.
My lord.
Heard Mr. A.R. Bhuya, learned counsel for the petitioner, who submits that this is the second time the petition is before this court. So pursuant to the order passed in the first round of litigation, the respondent authority, that is the Director of Elementary Education, has passed an order dated 25/7/2023, by which the claim of the petitioner has been rejected. (25/7/2023), bracket annexure 13. Stop, agree with the same. The petition is again before this court. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. P.K. Bora, Standing Counsel, Elementary, accepts notice on behalf of respondent numbers 1, 2, 4, 5, and 6. Ms. K. Fukan, learned government advocate, accepts notice on behalf of respondent numbers 3 and 6. 3 and 7. Sorry, 3 and 7. I think that's complete.
My lord.
Notice is therefore complete. Petitioners to serve requisite copies of the writ petition to the learned counsels appearing for the respondents today within 2 working days. List again after 4 weeks.
Obligement.
Item 31, submit.
Yes, Mr. Patgiri.
Yes, Krishna, it is also, my lord, the second round of litigation, my lord. In pursuance of the order dated, my lord, 21/3/2023, my lord, the proposal for provincialization has been forwarded to the government. And finally, see, my lord, I have an annex, my lord, page 81. The government returned the file to the director, my lord, asking for filing the review and appeal of WBC number. But till that, no appeal, no review has been filed, my lord.
Yes.
But it is reflected, my lord, to filing the review and appeal. But the court's order, my lord, kindly see, my lord, page 74.
What is that?
It At this case, notice may be government.
Okay, what about the instructions? Have you received instructions to file review? But this is the letter addressed to standing counsel.
Standing counsel 83.
Huh? Hmm. Mr. K.R. Padgiri, learned counsel for the petitioner, who submits that this is the second time the petition is before this court. Of the earlier writ petition being WPC number 3850 of 2021 was disposed of by this court, white order dated 21/3/2023, by which the state level
Scrutiny
committee was directed to
page 77, paragraph 13.
take necessary steps to facilitate the provincialization of the service of the petitioner within a time frame. The learned counsel submits that despite the same, the respondent authorities have not done anything, and they have advised their counsel to file review appeal before this court. To stop, he submits that neither a review nor an appeal has been filed by the respondents, and therefore the petition is again before this court through this writ petition. To support the submission, the learned counsel has drawn the attention of this court to Annexure 16 and Annexure 16 and 19.
18 and 19, madam.
Annexure 18 and 19 of the writ petition. Next, in view of above, issue notice of motion returnable by 4 weeks. Mr. P.K. Bora, Learned Standing Counsel, Elementary Education, accepts notice on behalf of respondent numbers 1, 2, and 4. Ms. N. Fukan, K. Fukan, Learned Government Advocate, accepts notice on behalf of respondent number 3. Notice is complete. Petitioner to furnish requisite copies of the writ petition to the learned counsels that they for the respondents today within 2 working days. List
Right.
again after 4 weeks.
Item 32. Item 32 and item 33 may be taken together, the same matter may. My lord, matter relating to my lord, this lowering in rank, my lord, the headmaster, my lord, who were, my lord, promoted in 2024 March. My lord, 83 number of my lord headmaster were, my lord, promoted after a recommendation of Departmental Promotion Committee, my lord.
Which district?
My lord, Baksa district of BTC, my lord. My lord, this order, my lord, if you order passed pursuant to, my lord, the Honorable High Court order, my lord, which is, my lord, page 80, my lord, paragraph 15.
Page?
Page 80, relevant portion, page 80, paragraph 15, my lord. That order, my lord, not complied. Because, my lord, Honorable High Court, my lord, directed to adjust from the bottom of the select list. Entire, my lord, recommendation, my lord, already, my lord, cancelled by own order.
Similar writ petition was taken up the other day. Are you aware about that?
My lord, yes, day before yesterday, your lordship passed a similar order, my lord. My lord, out of the same group, my lord, 29 petition earlier approaching.
The earlier one was which district?
Same district, my lord.
Bakta only.
Same list. Same list, my lord. Out of same list, my lord. Out of 83 teachers, earlier 29 teachers approached, my lord. At this time, my lord, in 32, 4 petitioners are there. In 33, my lord, there is 32 petitioners are
Both
there.
the writ petition pertains to Baksa.
Baksa, my lord.
Both.
Out of same list, my lord. Same order will cover the case, my lord. Then impugn order is there.
Where's the impugn order?
Impugn order, my lord, page 82. Annexure 14. Passed by my lord, this is secretary, BTC, education, my lord. And my lord, entire list recommendation of TPC, my lord, has been cancelled. The authority could have, my lord, adjust, my lord. There are number of vacancies are there, my lord. I have given list, my lord, this of 28 vacancies. And 20 petitioner, my lord, approach in earlier case, my lord. They could have easily, my lord, adjust the vacancies, my lord. Have given list of 28 vacancy, which is page 83, my lord.
Now, if you want me to come, they will say that there can be excessive.
No, I am not for adjustment.
How this order, because of this classification, they will get the opportunities to participate.
No, that is not the question.
My lord, it is not as per the direction of Honorable High Court.
Please bear with me, okay? Now you don't have to submit more. There's only one case that has been already, the order has been passed. So no need to submit. But Mr. S. Chauhan, learned counsel for the petitioners who submits that the petitioners are aggrieved with the communication dated 12/3/2026, by which it has been directed that the recommendation of promotion of headmasters/headmistress under Buxa district made by the DPC held on, what is the date of the DPC?
DPC,
4/3, is it?
yes,
4/3/2024
2024.
will be cancelled in view of the order passed by the High Court. White Common Order dated 12/6/2025 with WPC number 1735 of 2024 being the lead case. So the learned counsel submits that this court had not set aside the DPC minutes dated 4/3/2024, but had directed the respondent authorities concerned to follow Rule 14, is it?
My lord, Road 14.
Rule 14
Yes, my lord. Of 2018 rule.
of the rules of 2018
Yes.
and also adhere to the seniority position of the candidates. Who stopped this court had therefore directed that if the petitioners in those writ petitions were found to be senior to the persons who have already been selected, the already appointed persons will have to give way to their appointment. And that displacement should be done from the bottom of the list of the selected candidates. To stop, the learned counsel submits that instead of following the said procedure, the entire selection process is sought to be revoked by the impugned communication. To stop, the learned counsel submits that the DPC covers all the 4 districts under the BTD region, and therefore selectively withdrawing the recommendation made in respect of Buxa district only also amounts to violation of Article 14 of the Constitution of India. The learned counsel further submits that this court had also passed an interim order on a writ petition filed by similarly situated persons. That is order dated 6/4/2026 in WPC number 1987 of 2026. Bracket Syed Atur Rahman and 28 others versus State of Assam and 4 others. Close bracket. Stop the learned counsel, therefore submits that a similar order may be passed in the instant case. Next, para in view of above, issue notice of motion returnable by 4 weeks. Returnable by
For is Millard.
27. 27/4/2026. Miss N. Chaudhary, learned standing counsel, BTC accept notice on behalf of
All 4 respondents.
all the respondents. As such, notice is complete. Our petitioners shall, however, furnish requisite copies of the writ petition to her within 3 working days. Top in the interim, it is hereby directed that status quo as on date shall be maintained in case of the petitioners. Next para list the matter on 27/4/2026 along with WPC number 1987 of 2026. Same order in this
Well,
item
yes.
number 33.
33 Millard. Item 2, order who states.
Motion finished.
Wait, please, your lordship. My lord, regarding my lord, the address of the respondent number 9, I have already yesterday filed an IA for correction of the address, my lord, amendment of the address, cost title.
Where's the IA?
I yesterday filed, my lord, it will.
Hmm.
Serial number is there, my lord. 4219 /
We list it after the vacation.
Yes.
List this matter again after Bihu vacation.
After 20.
On 22/4/2026, along with the interlocutory application said to have been filed by the petitioner this morning.
Yes. In the
Under
main-
serial number
serial number 4219/2020.
4219/2026.
Yes.
Yes. Anything else?
Yes. And in the main case, there is the interim order that may be contained.
Till that next date, interim order passed earlier shall continue.
Problem.
Give extra copy.
I'll sir.
What is your good name? A. Banerjee, learned counsel appears for respondent number 5. Mr. U. Bhuya. S. Bhuya appears for the 1, 1, 2, and 3. Appears for the higher. Appears for the higher education department. All right. Next.
Item 20 for orders.
Yeah, topic, now it is under department because of this entry, it takes some time. We have to approach the final report also. May I please, your lordship, maybe see to
2017.
last order, my lord. My lord, the review was there unnecessarily filed only to delay this contempt matter, my lord. 9 years has been going to elapse, my lord.
Where is that review order?
Review already dismissed, my lord.
When?
Last
Where is
17th.
the, do you have a copy of the order?
No, my lord, the order has not been uploaded now.
Okay, you know the date and the case number?
231,
Review petition number
231 of 2025.
231 of 2025.
Yes, ma'am.
Dismissed on?
17/3. On the same date on which date this order was passed, my lord.
On the same day?
My lord.
What are you saying?
My lord, I submitted, my lord, your lordship, please to see the last order dated 17/3/2026, passed in this contempt matter, my lord.
Please write the review petition filed by the department. That is review petition number 231 of 2025 is said to have been dismissed. White order dated 17/3/2026. To stop, review was sought for reviewing the order, which according to the petitioner has not been complied with in the instant contempt petition. Stop. Mr. SMT Chisti Learned Counsel submits that since the review has been disposed recently, he may be given 2 weeks' time to obtain up-to-date instructions with regard to compliance of the court's direction. There is allowed. List again.
My lord, we have a date may kindly fix, my lord.
Yes, definitely. We'll fix a date. Just a minute.
23, my lord. 23/4, my lord.
We'll have it on 24.
24.
24/4.
My lord, much obliged.
Next.
Item 21.
So this is contempt against the order dated, my lord, 26/11/2021, my lord. Page 13.
Yes.
Direction was to appoint within 2 months, my lord.
Mr. Fukan?
The order which will be passed, my lord. It is a common order, my lord. And there was a confusion regarding, my lord, the 5 petitioners here, my lord, whether they have got the clear detail. Because the order was specific that the petitioner basically look into the petitioner's qualification and accordingly if they match the requirement, then they be given the job appointment, or otherwise it cannot be rejected. Therefore, there is some confusion regarding that, so it's my instruction on that. And from that, we can see trying on the last, we will see some more.
Several times opportunity has been granted to you.
Yes.
There was confusion that many reflections have been filed in this particular case, different cases. Some cases were not review petition have been filed. So whether this petition will be filed or not, that particular or whether we have to give some clarity to that much, it's up to you. It is civil and
Are you seeking time to file review? Huh? What confusion, Mr. Fukan? Which is the order, page 9?
Yes. Operative from page 13 on.
Actually, the last part of the
Yes, what is the direction?
direction is simple, my lord, that taking into consideration page 7, my lord,
Yes, read.
facts and circumstances of the case and the submissions of both the learned counsels and the order passed this petition is disposed of with the direction. The respondent should consider issuance of appointment orders to the petitioners in this case, in case they are found to be qualified otherwise within a period. In case, there's a big in case they are found to be qualified otherwise within a period of 2 months from the date of receipt of the copy of this order.
So say that
So exactly. So
they are qualified or they are not qualified. Say either of that. You cannot just sit like that.
Sometime.
No, sometime means what? 5 years have gone by, almost 5 years. On perusal of the order dated 26/11/2021, more particularly the last part, which is the operative portion of the order, the respondent authorities concerned are to consider appointing the petitioners in case they are found to be qualified within a period of 2 months. First of Mr. F. Ukan, Learned Counsel, submits that there were a number of cases filed and the respondent authorities require some more time to sort out the matter to comply with the court's direction. It is also seen that several opportunity has been granted, and therefore this court is of the view that the respondents are delaying the matter. For reasons which cannot be considered to be acceptable. But however, on the insistence of Mr. A. Fukan, one more opportunity is granted to the respondents to comply with the court's direction. Failing which, further consequential directions will follow. List again. How much time should you require? So that you don't take further time. List again. On 5th of May.
5th of May, Madam.
Yes.
Alright.
$22. We have the sanction and amount of rupee 545,000 Yeah.
We have received.
They have received the
Lordship, we have received. Petitioner has received the arrear salary.
Any document? Any document?
But
Lord-
some order is here, is it the sanction order that we have sanctioned?
Learned counsel for the petitioner, Miss
R. Medhi.
R. Mehdi, submits that the petitioner has received his area salary as directed by this court. Stop Mr. S.M.T. Chisti, Learned Counsel appearing for the respondent, agrees to the submission, and he also produces a copy of the sanction order. Issued by the Joint Secretary to the Government of Assam, Department of School Education, and addressed to the Accountant General, bracket A and E, Assam, whereby an amount of rupees 5,45,324 has been sanctioned as area salary of the petitioner. Next para, considering the above submissions, the contempt petition stands closed. Copy of the communication produced by Mr. S.M.T. Chisti, dated 16/2/2026, is retained in the record and marked as X for identification. Mhm. 23.
The area service will put on the leading into the financial pressure and give a shortage of budgetary provision lobby. And a time for weakness to the order by the director because now the area service will be leading
as per rule, in the next financial year, there is the exception. So some time I can,
My lord. My lord, the judgment is of 2 years old, my lord, 34, 2024, page 15, my lord. Operative portion at page 32, my lord. About 2 years, my lord.
When is that? Next budget means?
This coming. These budget, there's a shortage of budgetary provision, not be given.
My lord, the order is, judgment is of 34, 2024, page 15, and operative portion at page 32, my lord. Page 32, my lord. Paragraph 43, my lord. In view of the interference made by this court with the order dated so and the communication dated so, the petitioners are hereby directed to be reinstated in their respective service against the post as indicated in their cases in the order dated 31, 2021. The Director Elementary Education Assam is directed to release to the petitioners their salaries in arrears with effect from August 2021. Till the date of their such reinstatement in service and thereafter to release to them their current salaries.
How many petitioners are there?
Yes, my lord.
How many petitioners?
11 petitioners. my lord.
11.
They were terminated from service without any affording any opportunity or without following.
When were you reinstated?
Yes, my lord. They have been reinstated.
By which order? When?
And they have been reinstated.
This is the order of this. How to comply.
Give me the date.
Yes, my lord. I am giving.
Order dated 71/2026. All the petitions they were reset. Third page of it.
After 2 years.
Yes, my lord.
Why?
After 2 years. They are deliberately disobeying the directions passed by this honorable court, my lord.
What happened in between, Mr. Chishney? Order was passed on 30/4/24. Reinstatement is 12/17/2026. Then what does the order speak about regarding the salary?
Salary to pay their area salaries with effect from.
No. The compliance order.
Yes, my lord. Yes.
Anything mentioned here? Salary. They are reinstated in their original post as shown in their names. This assures with the compliance of the court's direction.
Payment of salary area salary that has been processed because of this shortage of budgetary provision that is almost paid.
It is not mentioned here anywhere that shortage is there. So from where do you develop that shortage? Hmm? This order is passed by whom? Elementary. Direct or elementary? Reinstatement, okay, reinstated after 2 years. Now, what about their pay?
The process. Process of budget allocation could not be in the last budgetary allocation for we need to pay on a next of the financial year.
Next financial year is also an ambiguous proposition, my lord. Financial year will be from April to up to 2027 March. So.
Okay, we'll give them some more time, but will not.
Yes, I'll take after the.
We'll listen May.
Yes.
Please write. The petitioners and approached this court by filing WPC number. Oh, there are a number of cases.
Two cases, my
Oh,
lord.
two cases.
8445 of 2022.
Now they've come together.
Yes,
What?
my lord.
The petitioners in both this writ petition are come together in this contempt.
Together, my lord. Same writ petitioners, initially their pays were upheld, subsequently they have been terminated. So that's why.
Please write like this. The present petitioners had earlier approached this court through WPC number 8445 of 2022 and
996 of 2022.
WPC number 996 of
2022.
2022.
Page 13, my lord.
Stop. Both the writ petitions were disposed of by common judgment and order dated 30/4/2024 with a direction to reinstate them back into service after setting aside their termination order. It was further directed that the petitioner shall be paid. The petitioners should be paid their area salary from the date of termination till their reinstatement, and thereafter their current salary should be paid also. Stop. However, I cancel. Although the petitioners have been reinstated, by order dated 17/1/2026, they have not been paid their salaries, area salaries. Have you received your current salaries?
Yes, my lord. Correct.
Except for their current salary. Stop. Therefore, the petitioners allege that the respondents have willfully and deliberately violated this court's direction. Next para, Mr. SMT Chisti, learned counsel appearing for the which respondent? How are you appearing? One. Appearing for the respondent. Only one. I see. On the file, they write only one name. No, in the file record cover, they always write one name only, although there are more than one. You appear for one. Both. Appearing for the respondent submits that as per the instructions received by him, the area salaries of the petitioners could not be released during the financial year 2026-2027 due to shortages of budgetary provision. Since during their reinstatement, the directorate from since you cancel, okay? Due to shortage of budgetary provision, full stop. However, the area salaries of the petitioners will be released as per rules in the next financial year 2027-2028, as and when the budgetary provision is received from the government under the respective head of accounts. Next para, considering the above instruction received by the learned counsel, the new financial year would begin from May.
No, it has already started from 1st of April.
Next financial year starts from 1st of April
Already started.
till the month of March 2027. Stop. Stop. The financial year spans for one financial year altogether. And therefore, the instructions received by Mr. SMT Chisti appears to be not concise and precise. Full stop. Since a direction has been given by this court for payment of area salary way back on 30/4/2024. It would be incumbent upon the respondents to clear the dues without further delay. Mr. SMT Kisti shall obtain precise instructions by the next date as to whether the budgetary provision has been made and when the amount would be released to the petitioner. List the matter again on 5th of May.
Obliged, my lord.
What's DCC? Okay. All right. You wanted adjournment in the morning.
The leading counsel is out especially.
Council is out. You wanted adjournment. So I just wanted to know why is it listed today? Why it's listed? Okay. Counter affidavit not filed, isn't it? Leading counsel for the no. The lead counsel of the petitioner, that is Mr.
M. Ahmed.
M. Ahmed, is said to be out of station, and therefore adjournment has been sought on his behalf. It is also seen that counter affidavit has not been filed by the Secondary Education Department, as paid for by Ms. N.M. Sharma, standing counsel, Secondary Education. Further 3 weeks time is granted
Obliged.
for filing counter affidavit. List again after 3 weeks on a date to be fixed by the registrar.
Item 25.
IA is for what? IA?
Lordship, in this case, my only prayer is
No. What is the IA for? Why do you look so surprised? This is your IA. You have filed IA. For resumption of service in the light of interim order passed by this court. Kind of application this. Yes, what are you saying?
my only prayer is to your lordship may kindly direct the respondent number 2 to issue focus notice to the respondent number 4.
Your prayer is that respondent number 2 should issue show cause notice to respondent number 4.
Yes.
Why? Who's respondent number 2 and who's respondent number 4?
Respondent number 4 is the principal of the Rangsina Senior Secondary School. And since the respondent number 4 had decided not to appear before this court, despite the several notices.
Yes, Ms. Sharma, what do you say? IA? Are you filing any affidavit of opposition in IA? You're not filing? Do you know what is the IA about? Hmm? Then what is that? 19/1/24. Show me who has 19,124. Clause 9 of what? OM. What is that? Please write, Miss N.M. Sharma, Learned Standing Counsel, Secondary Education Department, submits that she will not be filing counter affidavit against the IA. What about the respondent number 4? Anyone appearing? Stop. Please write, Lawazima Court's order dated 10/2/2026 indicates that neither ID card nor unserved notice is returned back from the respondent number 4. Stop. However, upon tracking the postal consignment, it is seen that the notice has been delivered to the addressee. Stop. As such, notice is accepted to be complete on respondent number 4. List this matter again. List this matter on. 23/4/2026. Yes.
26.
May I please, Lordship? That's a matter related to pension and retirement benefit, Lordship.
Today we are concerned with notice.
Lordship,
Next, respondent number
we have taken the steps, but it is
4.
ID card not returned, Lordship. As per office note.
From whom? Where's that flag P? Just show me, Master. Is there any flag P? What is that? Who's the who's the addressee?
Headmaster, This one number 4.
There's some mistake out here. Huh? This should have been respondent number 4 instead of 6. It starts with respondent number 4. Then it continues with respondent number 6. Respondent number 6 is AG Assam, Accountant General. Please write, office note dated 2/4/2026 indicates that notice has been issued. Indicates that neither AD card nor unserved notice has returned back from respondent number 4. Stop. However, the postal track consignment of notice sent to respondent number 6 shows
Oh,
that.
Lordship. Respondent,
Just a minute.
sorry, Lordship.
Respondent number 6 shows that the item has been delivered. Next para. It appears that there is some typographical mistake in the office note dated 2/4/2026. Instead of respondent number 6, it should have been respondent number 4. Since respondent number 6 is Accountant General Assam. To stop. Therefore, the poster journal wherein the item is said to have been delivered is accepted to be as respondent number 4 and not respondent number 6. Stop. Accordingly, notice is accepted to be complete on respondent number 4. List the matter again after 3 weeks on a date to be fixed by the registry. Respondents to file their counter affidavit in the meantime. You want me to record your name? What is your name? Miss M. Das, learned counsel, appears on behalf of Mr. S. K. Mehdi, Standing Counsel, Accountant General, Assam. You also want your name? Mr. U. Sharma for respondent number 1 to 3. That's all. J. K. Fukan for respondent number 5. R.M. Barua for respondent number 7.
Date may be fixed, Lordship, after vacation.
Registry will fix a date. What did I say? List again after 3 weeks? On a date will fix this.
27.
27.
May I please, your Lordship.
Hmm.
My lord, we have taken steps upon respondent number 7.
7.
Yes, Lordship. Speed post was directed, Lordship.
Okay. Upon perusal of the office note dated 4/4/2026, which shows that on tracking the postal consignment of the notice sent to respondent number 7, the item was delivered, notice upon respondent number 7 is said to be complete, is accepted to be complete. List the matter. Again, after 3 weeks on a date to be fixed by the registry. Respondents to file their counter affidavit. Mr. U. Sharma, higher education, secondary education appears for the state department.
My lord, may I say one thing, Lordship?
Yes.
My lord, the matter pertaining to deprovincialization of the service of the petitioner. He is appointed as Arabic teacher, Lordship. May I pay that the impinged order may be stayed in the meantime, Lordship. Otherwise, he was provincialized in due process, Lordship.
Was it stayed in the first day? It was not stayed. So why should we stay now at this stage?
It was not stayed on the motion day, Lordship. The respondent number 7 was given a chance, he has not appeared, Lordship. My lord, may I say that in the meantime, Lordship, otherwise he has rendered about 30 years service in Bensal School.
No, what do you want to stay? What do you want to stay for?
The page 68, Lordship.
68. What is 68?
Page 68, this is the deprovincialization order passed by the respondent number 1, Lordship.
What is the date?
Lordship, pardon.
What is the date of deprovincialization?
This is the date, Lordship, 30 April 2022.
Okay, after 4 years, you want to
No,
stay.
Lordship, but it was not communicated. I have stated, Lordship, may kindly see last page. Page 73, Lordship, may kindly see.
73.
Last page, Lordship, annexure 20. After this communication on 12/12/25, I came to know that I am deprovincialized. Lordship, may kindly see. This was communicated to the headmaster of the school. And thereafter, my salary was stopped. And then I came to know that I was deprovincialized.
When was your salary stopped?
For the month of November of 2025 was paid, but thereafter the
December not paid.
yes, Lordship. But thereafter the respondent number 6 communicated this letter to respondent number 7, Lordship.
It's too late in a day now to stay that. We'll consider the entire thing. Let them file their affidavit.
Otherwise, Lordship, my humble prayer, he is rendered about 30 years in Bensar School. Thereafter, only in the year 2021, he was provincialized. Thereafter, the proposal for implementation.
Oh, we'll see. No.
He will suffer, whole life has gone, Lordship.
Writ petition is pending, Mr. Counsel. We'll see. Let us take a decision this way or that way once the affidavit is filed. Next.
Then a date may kindly be given, Lordship.
Registry will give a date after 3 weeks. Mr. Sharma, you file affidavit, okay? Don't delay. File.
Item 40, subsidies.
May it please your lordships.
Please.
Lordship, kindly peruse the last order dated 13/2/2026.
You're working as on today? Are you working?
Yes, I'm still working.
Yes, what is your instruction?
That case was listed on 13/2/2026. And on your instruction, they have fixed this case 8 April 2026. The petitioner did not get salaries. How he can survive, lordships? Now they stated that they don't have any instruction. Is this way to submit like this, lordships?
Yes, this is what, which department? Higher, secondary.
Lordship kindly gives a short date. Because without having instruction, yeah, বড় ভাল পাইছে। Because inquiry has already been conducted by the government director. No result is coming out. And petitioner also appeared before this inquiry committee.
So what is your case otherwise, Ms. Devi? You have said that you have not received salary since the year 2006.
Yes, my lord. He was selected, my lord, in the year 1999.
And yet you are still working.
Initially, he was appointed in LP school. Then Lordship school was amalgamated. It's become high school, my lord. Since then, 2006, he did not get salary. Up to 2026, he got salary, but because he was appointed 1999.
No, you say he did not get, again you say he got salary. What do you mean?
Before 26 months, he got salary. But after now, after 2026, he did not pay, he did not get any salaries.
Up till when did you get the salary?
Lordship, kindly peruse the page 63, annexer 70. That is the report in respect of petitioner, my lordships. Earlier, I approached this honorable court, my lord. That is in the year 2016. WBC number 5392, 2016. Then Lordship kindly turn Annexure 21, page 68. Director, Secondary Education, forwarded letter to the Secretary of the Government regarding this petitioner's case. And headmaster also got notice, my lord, but he did not turn up. Service has been completed. Then, hello.
Where's the order passing? In the earlier round,
Page 55.
expert committee.
Yes, my lord.
Now, have they decided anything? What is the report? Is
It's
this-
already been completed, my lord. So
Huh?
far, my knowledge is goes.
Sorry?
But the
Not completed.
expert committee, they have made an inquiry. So far, my knowledge is goes, my lord. But we did not get any report, my lord. Let them bring report, my lord. The thing is,
293.
reported that he will be.
Well, 293. What is page 58?
'53, '56.
There's some mistake here also. Regarding case number 5293. Whose case is this? 5293.
No, no, not, my lord, it is a typing mistake.
Oh, that's one.
Translated copy of the translated copy of the Annexure 12. The case was, my lord, 5392. It 5392 whole again. 52.
What does it say, this letter?
Inspector School wrote a letter to the director, my lord.
After the
Para 1, it is in that from
No,
the.
just listen.
Yes,
After the disposal of your writ petition,
yes, my lord.
5392,
Yes, my lord.
this letter has been written.
Yes, my lord.
Saying what? Please read from the beginning.
Para 1, it is seen from the records that the petitioner, Sri Ranjit Burman, assistant teacher of Dolasol High School, was originally appointed as an assistant teacher in Adabari ME School in the scale of pay by the District Elementary Education Officer Nalbari, height memo dated 4/12/1999. And he had joined the post 6/12/1998 and the draw salary accordingly. The post was originally created 24/4/1998. Then
It's
80
1999.
99.
From where are you reading?
The post was originally created by government letter dated 24/4/1992.
1998.
Translated copy actually.
He joined the post on 6/12/1999. A lot of typing mistakes in
Yes,
your
my lord, lot of typing mistakes. Actually,
98.
it is
Should be
not-
99. You've written
it's the
98.
blur. My lord, I have the type it out actually, annex 12 from 12.
To make it easier, you have a typed copy, but
Yes, yes.
that isn't the type copy, more confusion.
Yes,
Everything
yes.
is wrong here and there. So you annex a type copy, proper
Yes,
type
my lord,
copy.
I will provide one.
Petitioner shall on the prayer of Miss K. Devi, learned counsel for the petitioner, the petitioner allowed to replace annexure 12 of the
Yeah,
is allowed to replace the type copy
worthless.
of annexure 12
Page 58.
by a duly corrected and verified type copy. Since the one which is annexed has typographical mistakes.
Yes, my lord. চাব লাগিব খুপুনি মাৰি মাৰি চাইছো নাই ক্লাইণ্টক মাতি আনিম টেলিফোন আনিম
Stop the same shall be done within a period of 2 weeks from today. As paid for by Miss N.M. Sharma, learned standing counsel, Secondary Education Department. Further 3 weeks time is granted.
But
Opens
times may be allowed because they need they will give the instruction. Order has been passed by on
1 week
30.
will go. Who is going coming? 1 week will go like that. Further 3 weeks time is granted
Says contrast.
to obtain instructions to file counter affidavit.
Give a date.
List again on so and so.
Oblige your receipts. What did you?
Permission at 6.
My lord, consecutive 3 times they have taken times for this reason. So my lord, my prayer is that this last chance to be given, when after that better may be disposed of.
What is the matter?
My lord, initially the petitioners was allowed to draw, my lord, the 3 non-compatible, my lord, in advance increment on acquiring the PhD. And as per the OM notification, but the subsequently that was withdrawn without showing any reason. And in spite of the filing of representation after representation, that has not been considered. So this is my case, my lord.
Increments is on what basis are you
It is
drawing?
on the basis of the OM, that is 2012 OM, my lord.
How many petitioners?
Only one petition, my lord.
Okay, what are you?
My lord.
You are a lecturer.
I am a lecturer, my lord, associate professor.
You are entitled to increment as per the UGC regulation.
Yes, my lord. Everything is there, my lord, nothing is dispute, but only so far the my lord increment is there. It is, I am entitled, I was allowed to draw. In my other colleague, they are also allowed, but I don't know, my lord, why these things has been withdrawn again. They are not showing any reason why it is there.
Okay, further 2 weeks time is granted to Mr. D. Upamanya to receive instructions and to file affidavit. List the matter again on.
My junior is drawing more salary than me, but I am not getting.
Yeah, please, your lordship, kindly take up the matter after some time.
No, if you have received the records, why do you want adjournment? Huh? Yes. What is that record? What record is that? No, it's still not making any sense. Let us see. Penalty was imposed upon them. Who are they? Who are the petitioners? Lecturer in AMC. And some penalty was imposed upon them. Reduction to lower grade. On what basis have you imposed the penalty? NOC means for? Mr. Dupamanya, your adjournment will grant you, but tell us, what is this? Why did you impose the penalty? What is the reason? No, I'm not asking you what is there in the records. I'm asking you, madam, yes, you also tell me. Why penalty was imposed? On what ground?
Lordship, I have to take the instruction as my senior is engaged in another court.
A straightforward list again after the vacation. On a date to be fixed by the registry. Mr. D. Upamanya shall produce the records, which he submits that has been traced out today. And is going to be handed over to him. Okay, next.
I think 12.
No, this code will not go through anything. See, you have to tell me, you have to submit. You have to submit. Mr. Bhuya, what is this case?
My lord, the matter relates to, my lord, regularization of service and, my lord, the impugned speaking order which they have passed. They have said, my lord, that my case is not, was not considered by the screening committee and therefore the benefit cannot be given.
You have challenged the speaking order.
Speaking order, my
Let
lord.
us-
Now,
This is the first round, second round?
no, my lord, this is the first round of the petitioner, my lord.
Where's the speaking order?
No, my lord, this is the second round. Speaking order is at page 95, annexure 16, my lord.
95.
My lord.
And the
My lord, crack.
and the writ petition filed by you, the order?
My
Is it
lord,
page 97?
Yes, my lord, the order, my lord, maybe please.
97.
Yes, my lord. Page number, my lord, 83, operative part starts from page 86, my lord.
Oh, 86. Yes,
My lord.
86.
My lord, can skip the first part from page 87. My
How
lord,
many
having-
petitioners?
My lord.
How many of them?
My lord, only two petitioner at present, my lord.
Earlier,
my lord, there were altogether, my lord, 30,
Vibhuti.
14 numbers of petitioners were there, my lord.
Okay, what was your grievance?
My lord, the facts of the case is that, my lord, there is a direction passed by this honorable court, my lord, that the exercise of, my lord, for the purpose of, my lord, may kindly peruse this paragraph, my lord, page 87, from by this court, having regard to the facts above and the earlier order passed by this court, the writ petition stand disposed of in line with the earlier orders to the effect that the Commissioner and Secretary to the Government of Assam Elementary Education Department is now to take necessary steps toward release of arrear and current salaries of the 14 petitioners herein. While undertaking this exercise, the said respondent authority is allowed to cause inquiry as may be required. Liberty is also granted to the Commissioner and Secretary to make necessary communication to the Finance Department towards the grant of necessary sanction. It is made clear that entitlement to salary, arrear and current shall be subject to the exercise to be undertaken. At the end of the inquiry, if the respondent authority is satisfied of the bona fide claim of the petitioner, necessary payment by way of arrear and current salary shall be made to each of the petitioners. it is also made clear that the exercise to be undertaken for making inquiry and reaching a conclusion by the respondent authorities shall be completed within a period of 6 weeks from today. In view of the above, my lord, the petition was disposed of, my lord. Now, my lord, though, my lord, order had been passed, but it had not been complied with, my lord. So therefore, a contempt proceeding had been initiated, my lord. The order of the contempt, my lord, is at page 94. And when this proceeding was pending, my lord, this impugned speaking order at page 95, annexure 16, came to be passed, my lord. Now, my lord, what they have done, they have said that we could not be, my lord, adjusted or, my lord, accommodated under the 2017 Act in any of the post of tutor or teacher under illegal irregular category. The claim of arrear salary therefore does not arise and its hence rejected. My lord, the decision is at page 96, my lord.
All right, they have filed affidavit.
No, my lord, one affidavit has been filed, my lord, but in that affidavit, certain things they have not brought on record. So therefore, my lord, this honorable court has repeatedly directed that the issue, my lord, one thing, my lord, on the last occasion, the honorable court was pleased to consider the regularization order, which is at page 43 in respect of these petitioners, my lord. By way of this order, my lord, our services were regularized way back, my lord, on, my lord, 30th of June 2006. So thereafter, my lord, we had been accommodated in the various schools. We were rendering our services, but the salary has not been paid. That was the crux of the case. Now, my lord, what they have done, they have said that we fall in the category of illegal and irregular. My lord, once we had already been regularized, my lord, the question of illegal and irregular is no more in force, my lord. So therefore, my lord, they are required to treat us as a regular teacher and our salary ought to have released. That has not been done, my lord. Our regularization order is at page 43, my lord.
Mr. Talukdar, what instructions have you had?
Now, petitioner, just immediately police
No, double fist.
Yes, sir. By earlier affidavit filed by the commissioner, madam, that was not entirely the document not now that now I is it's action. Will be allowed to file affidavit on behalf of director.
Earlier, who had filed?
Phone number
Number one.
Earlier was filed by the, my lord, secretary, my lord. Respondent one, my lord.
And director is number two.
My lord, my lord.
Let him file, okay then.
My lord. But my lord, the case is very, my lord, clear. The instruction which my learned friend has brought in, my lord, we are now without the current salary also, my lord. That is the difficulty, my lord. My lord, my lord.
Mr. B. Talukdar, Learned Counsel for the respondent number. For the respondent number,
2.
Learned Standing Counsel, Elementary Education Department submits that he has received instructions from respondent number 2 and prays that he may be given 2 weeks time to file the affidavit of respondent number 2. Praise aloud. List again on sense.
Oblige.
Yes.
My lord, affidavit of respondent number 5 is necessary, my lord.
Huh?
Affidavit of respondent number 5 is necessary.
Is?
Affidavit of respondent number 5 is necessary, my lord.
Is necessary.
Yes.
Who's respondent number 5?
NCT.
Mr. ILM. Learned Standing Counsel, NCT. Submits that The affidavit has been sent for vetting and prays for 2 weeks' time to file the same. Praise the Lord. List again. Interim order passed alia shall continue till the next date of listing.
May it please your lordship. The petitioner before your lordship is a private university, my lord, established under the Assam Private Universities Act, my lord. The matter pertains to, my lord, non-granting of approval of the statutes, my lord. Under the Act, Assam Private Universities Act, my lord, I am required to frame my statutes and forward it to the government, my lord. The government, if it finds something wrong in that, my lord, within a period of 2 months, it has to either reject it or ask for rectification. Now, the first statutes were submitted, my lord. The government pointed out some deficiencies. We corrected everything, and my lord, on 15/6/2023, we submitted the corrected statutes. Now we are in the month of April 2026, my lord. Almost 3 years have gone by, my lord. No response from them, my lord. Lordship, if your lordship kindly peruses the order dated 25/2, passed by this honorable court. Then the next order also, my lord, 9/3. Even the Commissioner and Secretary, Department of Higher Education had appeared, my lord, through VC. And sort of an assurance was given to the Honorable Court that the matter will be placed before the next cabinet. Then lordship comes to 18/3, my lord. It was placed without any assigning any reasons. The matter has been deferred. It's a matter of grant of the approval to the first statutes, my lord. Why this is being taken as an adversarial litigation, my lord, I do not understand.
What is the university called?
It's the Girijananda Chaudhary University.
What is that?
It's a private university.
No.
Yes.
You're giving me a piece of paper. What is there?
They're unnecessarily dragging the matter, my lord. Absolutely that, my lord. The Act does not contemplate that the matter has to be approved by the cabinet, my lord. Every government decision is not approved by the cabinet. The law requires that the government is. May I place the law, my lord?
No, just a minute. I'm reading the instruction.
Copy of the instruction is also marked to me. এখন নাই দিয়া আমাক নাই দিছে আমাক মোৰ লগত নাই মোক দিয়া নাই The model code of conduct will come in the way. Grant of approval to the statutes.
So what will happen now? Model of code of conduct will go on till when?
Code of conduct will remain till May, my lord.
May.
4th of May.
4th of May is the declaration of results.
4th of May is the results.
We'll list
Then
it after that. We'll list after that. And you, if nothing is taken up, you satisfy the court that the cabinet's approval is not required or whatever. We've been waiting for this for some time. That's why we'll grant some more time.
Almost 2 years, 3 years will go by, my lord, by that time. They are required to do it within 3 months.
There
2
was
months.
the orders passed by this court wherein the learned standing counsel for the higher education was required to obtain instructions as regards the decision taken by the cabinet. Stop today, Mr. S. Bhuya, learned counsel appearing for the higher education department, submits that he has been instructed that in view of the enforcement of the model code of conduct, the cabinet cannot have it sitting. And therefore, he prays that the matter be listed after 4th of May 2026. Considering the submission, list this matter on
Not on 14.5. I'll not be here. Let it be on 18.5.
19.5.
19.5.
This is item 15.
Yes.
All right, come back.
May I pray, Your Lordship?
Yes.
Mr. M.R. Khondokar is out of station, my lord. I pray for some time, my lord, on behalf of M.R. Khondokar. my lord.
On the request made on behalf of Mr. M.R. Khandakar, learned counsel for the petitioner. Matter stands adjourned.
After vacation, my lord, after vacation.
Matter stands adjourned to be listed again after the Bihu vacation.
Obliged, my lord.
May it please your lordship.
My lord. As portals, by complexion, the mentality of situation at this stage. That issue. Be really enough.
Maintainability.
And the another statement of IIT work. That I support the, I support the PG dot. And the percent of the week. But what all past to come, whatever relief the works. Now they have already taken the in order. The petitioner is already recorded in the fee, filed in the fee. Before the issue. It has been registered and notices have been issued. Transferred to respondents. Now what that is pending. That I is treatment should work. So the same cause of actions, same set of facts, same parties, authorities, the cases are pending. And that I am finding very difficult to defend themselves. If you go to the books, one has. Either it's not to be good at that bit. Or company here or.
Where was the appeal filed?
Appeal file, my
To
lord.
the visitor?
Appeal of 30/11/2024.
What is the status now?
No. No issue. No. Whatever. My lord, I am satisfied before lordship regarding that issue, whether this matter is maintainable or not. I will by giving the judgments. Your lordship heard me today itself because I have no any service till today. And more than 2 years have already left. No action has been taken by the ex-president of India passing the order. So thereby, I may be allowed to heart my petition, my lord, because of that. Today is the fix for passing the interim order, my lord. And they have filed in a preliminary objection without citing, without the reply of the parawise in my petition. So that they wanted before the honorable court a piecemeal manner by filing this preliminary affidavit, my lord. So your lordship go to before going to that, I may be allowed to heard, and your lordship go to your lordship order dated 17/12/2025, man. May I read? Yes, I'm going to satisfy before lordship whether my petition is maintainable or not. If this is not maintainable, your lordship pass an order, I know of this. My lord, your lordship, I am read, my lord, your
No.
lordship order dated so and so 17.
No, it's okay. I'm reading myself. Just a minute. Okay.
My lord. And your lordship go to the page 216, my learned senior friend, there IIT file in a preliminary affidavit, my lord, para 4, page number 216, man.
I'm still reading the orders. Just a minute, please. Some affidavit has been filed?
Yes, madam. They file an affidavit, preliminary affidavit.
Preliminary affidavit.
And I also file reply, madam.
Reply. Okay. Hmm.
So thereby I'm today satisfied with your lordship, whether it's the maintainable lord.
That pendency of that appeal also was submitted. On the first day itself, it was submitted.
Now, anything that appeal, without doing that, particularly really similar for the actions.
How long we are waiting for last 2 years, man?
So where is that? Where's the evidence that notice has been issued, all that, that has been done?
Yes.
In your affidavit?
My appeal was annexed, my lord.
186.
Page 186.
This is the appeal, then where's the notice?
No notice, my lord. Remainder, but they did do it, man.
That is what I'm asking you. Where is the notice?
My lord, they are going to delay the practice, man.
Mr. Where's the notice? Proceeding means the appeal was filed when? In the year 2024?
Yes, my lord. Appeal was filed on 30/11/2024.
And you say the matter is proceeding now only.
No, my lord, nothing.
No, but show
At
me
least I will be satisfied, my lord. Your lordship heard me.
in your submission, you say the matter is proceeding, notice was issued to the parties. Where is the evidence? Just give me that evidence. Notice is proceeding like that, this, that. So we may await outcome. On what basis you are saying that? All that we see is a copy of the appeal only, filed in 2024.
We had a dilemma now, where to defend ourselves here or defend ourselves there. And we cannot compare to lordship defend ourselves.
There's no question of being dilemma. You defend here, you defend there also. There's no question of choosing. I'll only defend here, I'll not defend there. You defend there if some notice is issued, if you are supposed to make a presentation, defend there. You defend here also. The question is, can we go simultaneously? What you're saying, this out here and that out there also. But if you say that things are moving there, you show me the evidence, things are moving. So far as the petition is concerned, nothing is happening. Since 2024, nothing is happening. He's out of job. Definitely is endeavorable to get the matter speeded up. You have to satisfy the court that things are moving. Then only I can consider.
In the meantime, my petition may be heard, my lord. Yes, my lord. I will satisfy, my lord.
Proceeding.
My lord, Honorable Supreme Court clearly state that, my lord, there is no bar at all. I am going to submit before lordship. I am filing reply also. Your lordship go to it, my lord. No, if, my lord, this petition, my petition is challenging the, my lord, regarding, my lord, their maintainability, my lord, please may kindly say para 3, page 215, my lord.
No, but see, it may not be a bar, as you say, but it would be better to wait for the outcome.
No, my lord.
If things are...
No, my lord. Yet, my lord, Honorable Apex Court clearly stated on what grounds.
Show me the apex court.
Yes, ma'am.
Show me. Which case?
Para 14, my lord. Yes. My lord, your lordship, first your lordship go to para 14.
Whirlpool Corporation
My lord,
versus Registrar of Trademarks.
Yes, para 14, my lord.
1998, 8 SCC 1.
My lord.
1998, 8 SCC 1. You also have a look.
Yes.
Para 14.
No, yes, I'm going to, my lord. Read, my lord. Your lordship got it, my lord?
Yes.
The power to issue prerogative writ under Article 226 of the Constitution is plenary in nature and is not limited by any other provisions of the Constitution. This power can be exercised by the High Court not only for the issuing writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, for the enforcement of any of the fundamental rights contained in Part 3 of the Constitution, but also for any other purpose. Under Article 226 Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition, but the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But alternative remedy has been consistently held by the court not to operate as a bar in at least 3 contingencies, namely, where the writ petition has been filed for the enforcement of any of the fundamental rights, or where there has been a violation of the principles of natural justice, or 3 is an important matter, where the order or proceedings are wholly without jurisdiction or the virus of an act is salient. My point is, my lord, we are on where the proceedings are wrongly without jurisdiction, my lord. Because of that two simultaneous, first, my lord, report was submitted, my lord, and but that now thereafter again, my lord, they issue a, my lord, charge sheet. So that jurisdiction has no jurisdiction or IRT, my lord.
What is that internal complaints committee?
Yes, internal.
GICC.
Yes, they submitted report, your lordship, first order there, my lord.
No, GICC made a report.
Yes, they
So
made
that
a
report was acted upon as a complaint
yes, my lord.
and proceeding was drawn.
Proceeding was done,
What is wrong in that?
my lord.
What is wrong in that?
Wrong means, my lord, is then cannot be taken into treated as a preliminary inquiry, my lord. There's a specific act is there. On the basis of that act, the committee was constituted, and they have submitted a report, and they have to pass an order, any punishment. And without doing that, they again, my lord, under 14, they issue a charge sheet. Cannot, my lord, they cannot be taken. We are challenged before this honorable court.
Correct.
That they have no jurisdiction at all. So thereby, this third, my lord, where the order or proceedings are wholly without jurisdiction, is I am challenged before lordship. This is not required, my lord. This is maintainable because of that, my lord. And my lord, there are again, my lord, there is a plethora of the case law on this point, but to cut down this circle of forensic whirlpool, we would rely on some old decision of the evolutionary era of the constitutional law, as they still hold the field. Rashid Ahmed versus Municipal Board, Karina, laid down that existence of an adequate legal remedy was a factor to be taken into consideration in the matter of the granting writs. This was followed by the another Rashid case, namely so-and-so, which reiterated above proposition, held that where alternate remedy existed, it would be a sound exercise of a discretion to refuse to interfere in a petition under Article 226. This proposition was, however, qualified by the significant words, unless there are good grounds, therefore, which indicated that alternative remedy would not operate as an absolute bar, and that writ petition under 226 could still be entertained in exceptional circumstances.
So keyword is exceptional circumstance.
That means, my lord, your
Is
lordship.
your case an exceptional circumstance?
Yes, my lord, because of that, they have no at all jurisdiction.
That is why that will be the merit of the case.
Yes, my lord.
Challenge has been made whether they have the jurisdiction to treat
Yes.
that GCICC report as a plenary report or not.
Yes, my lord.
Is a case to be decided by this court on merit. It
yes,
cannot
my
be a preliminary issue.
Yes, sir. Where their
If-
order of proceeding wholly without jurisdiction. If
the report of GCICC goes, entire writ petition, the entire proceeding goes.
no.
All right.
Yes.
What no?
No, your
Do
lordship.
you understand what I'm saying? If the GCICC report,
My lord.
on the basis of which the departmental proceeding is drawn,
My lord.
is found to be not maintainable,
Yes, my lord.
so the entire proceeding goes, appointment, the dismissal also goes, everything goes.
My lord.
Means it goes in your favor.
Yes, my lord.
So that would be the merit of the case, you see. It cannot be a preliminary question to be decided whether that can be treated or not. So that is why the matter has to be heard.
My lord.
And maintainability, you're saying, on the basis of that visitor being the appellate authority, as per the statutes, visitor is the appellate authority. Huh. So if the person has gone in appeal before that authority, so at the same time, simultaneously filing a writ petition would not be advisable, or to decide the matter will not be advisable. That's what he's saying. But your submission, which you say that parties have been notified, action has been taken, that is not available anywhere. Otherwise, we'll be bound to accept the petitioner's plea that there's nothing been done for the last 2 years. Why should we wait for that?
Or necessary instructions. That I can show, but that incident don't go this. Only 148 of house.
Mr. Bora,
My lord.
we'll wait for some time. I understand your anxiety that it can proceed, but
2 years have already passed. They have nothing to do it. I have also remainder also given, but they
no,
did not
let
do it.
let learned senior counsel get the instructions required as far as what is the actual status. If the court finds that there's nothing is happening, then I think we'll perhaps consider going ahead with this matter. You reply. Don't file in stage wise.
Yes, my lord.
See, a person is out of job for the last 2 years. He'll be his anxiety to get the matter decided as early as possible. And here you are filing one application, one preliminary objection only. If this fails, then I'll file a merit thing. This is time consuming. Time consuming.
They
So you answered everything by way of an affidavit. You also look into the fact as to whether the question of law which has been evolved now, whether that report of the GCICC can be treated as a preliminary inquiry report. Yes or no? They say no. He says no, it cannot be. So you answer that also. When will you do that? When will you do that? I'll record that. If you do not file, then we'll proceed. First, case is valid because safe course of action. One has to be proved. No, that is not a court, no? That is not a court. It is appellate authority only. What is that?
When resident order will come, my lord, without heard. Can you raise the difficulty applicable?
Now, whether this university can find out, you find out what is happening. Otherwise, we will say that we don't know anything. We will say that there's nothing, there's no response from the appellate authority. So it is for you to satisfy the court. If you cannot satisfy, then why should we wait like that? Where's the appeal? Show me page.
My lord.
Appeal.
Appeal, my lord, page 186.
186. Copy has gone to the university also. I mean the IIT.
Yes, my lord.
Where is that? I don't think you have given copy. This to the visitors.
A reminder also given on 13 January 2025, my lord.
How you have sent by speed post?
Yes, my lord. Page 207. Receive on 3/12/2024. This is a consign report, my lord. 208.
Where is the provision for appeal to the visitor?
Yes.
Page.
Appeal, my lord.
It has to be sent directly or what? Not through the not through the IIT.
227, my lord, 10, my lord. 227, my lord, last, my lord, below, my lord, 10.
No, 227.
227, a member of the staff aggrieved by any order imposing. Yes, ma'am, I'm saying.
227.
Last paragraph.
It's a running page. Which one?
10, my lord, last.
The board. A member of the staff. This one.
Agreed by any imposing penalty was by the direct or against the shall be entitled to prefer an appeal to the board against the order, and there should be no further appeal from the decision of the board. And a member agreed by any order passed by the or by the board against him, inflicting a penalty on him shall be entitled to prefer an appeal to the visitor against the order. And next level says, but if the court to rule an appeal against order imposing penalty like to the they may explore motion or otherwise confident also the case, then decision proceeding to take and pursue them. So that the court has got complete power to give grant relief to the
Time, there's a limitation also. Is your appeal within time?
Yes, within time.
It says 3 months.
My lord.
You have filed within 3 months.
Yes, my lord. File, my lord. Imposition of penalty on 5/10/2024 and the appeal file on 30/11/2020 within 1 month. File.
Okay, you obtain instructions and you file an affidavit on merit also.
Already 2 years lapsed, man.
Please write, parties are represented by the respective counsels. Stop. Brief facts of the case has been recorded in the order dated 17/12/2025 of this court, passed by this court. Mr. N. Bora, learned counsel for the petitioner, submits that the matter may be taken up for consideration since the appellate authority has failed to consider the appeal filed by the petitioner. Which was filed on
30/11/2024.
30/11/2024. Stop. He also submits that there is no bar for this court to consider the case in view of the decision of the apex court in Whirlpool Corporation versus Registrar of Trade Marks, Mumbai, and others. Reported in 1998, 8 SCC 1. Paragraph number 14 and 15. Mr. R.P. Gauhati, learned senior counsel.
that says a will the alternative regulations on their part, but a court has a call. Here, alternative not a will case in both the alternative.
That is submission. That is submission. I'm not hearing that matter now. Mr. R.P. Gauhati, learned senior counsel, assisted by Mr. A.B. Day for the respondent IIT Gauhati. Respondent IIT Gauhati submits that as per the instructions received by him, notice has been issued by the appellate authority on the appeal filed by the petitioner. And therefore, pending consideration of the appeal, the writ petition may not be considered simultaneously. To stop, he also submits that a preliminary objection has been filed by the respondent IIT on the maintainability of the writ petition. Next para. It is, however, seen that there are no materials brought to the notice of this court as to what action has been taken on the appeal filed by the petitioner. Respondent IIT would have to satisfy the court that some steps have been taken in that regard by the next date. Stop further. The maintainability of the writ petition itself correlates with the merit of the case in the prima facie view of this court. Since the petitioner has questioned the acceptance of the report submitted by the Internal Complaints Committee as a preliminary report to initiate proceeding against the petitioner. Stop. Therefore, the respondent IIT shall file their affidavit of opposition on the merits of the case as well by the next date, so that the court can proceed with the matter subject to further instructions being received with regards to the appeal filed by the petitioner before the visitor of IIT, that is the President of India. List again on. All right. You will file affidavit and find out what has happened. All right.
Much left.
Please, Your Worship. This case, my landlord was directed to obtain instruction by order dated 6/3/26 regarding the status of the resignation of the petitioner. 6/3/20.
Yes. What is the instruction? Can you tell me? Not accepted.
There's no question of.
What is your case otherwise?
My case is I have submitted resignation.
Later on, you want to
due
withdraw
to
it.
Due to illness, Your Worship.
Then later on, you withdrew it.
Subsequently, I have submitted representation because due to illness, I have given my.
You want to resign or you want to continue?
I want to continue.
Or you want to continue? But you have submitted resignation letter.
Resignation.
And which was not accepted.
Not accepted and.
So you should be continued. That's what you're saying.
Continue.
And you're also saying that.
Very next day, he submitted the resignation letter, which was not accepted. Which was not accepted by the department.
So if resignation was not accepted, then allow him to continue. Huh? Huh? He has not joined. Then what will happen to him?
I have joined in 2022. I have joined 2022. I have service long back. I resignation on 9/5/2024. After 2 years.
What are you? You are a PG teacher.
Yes, postgraduate teacher. Yes.
Ahmedabad Higher Secondary School.
It's a PG.
Principal is a party here.
Party, Your Worship.
Who is appearing for principal?
No.
Whether he has joined or not, they will be able to say. We don't know what is what. Anyone appearing for respondent number 6?
Name shown.
By whom?
At 2 I am name shown.
M. Chaudhary and A. What is this?
Hey, Hawari.
Hawari. The name is shown. This is item number
18 years.
15.
Take up to Eileen.
Ms. R. Barua, Learned Standing Counsel, Secondary Education Department submits that she has received instructions and prays for 10 days time to file a counter affidavit. Prayers allowed. List the matter on 8.5. One more line. The remaining respondents shall also file their affidavit in opposition. To stop, the respondent number 6 also shall inform the court as to whether the petitioner had joined what is 22.4? Respond. What did I say? Respondent number? Inform the court about the attendance of the petitioner in the state higher secondary school by way of an affidavit by the next date. You inform the other side also. Principal, counsel for the principal, they should give us some information.
8.5.
Twist on 8.5.
90.
Yes.
Petitioner before your lordship for non-creation of supernumerary post after his promotion to
You file an affidavit, okay? This is the second time the matter is listed. Mr. S.M.T. Chisti, Learned Standing Counsel, Elementary Education, prays for and is granted for the 3 weeks time to receive instructions and to file counter affidavit. List again on 13.5.
34, 35 and 36 of the supply list.
My lord, here, my lord, leave salary has not been paid to the petitioner, my lord. Date may be fixed, my lord, in the meantime. I will also file the reply, my lord, in the meantime, my lord.
Mr.
BK Das, my lord.
BK Das, Learned Counsel appears for the petitioner, and Mr. J. Bora, S. Bora, Learned SC. Huh? Urban Water Supply, is it?
Yes.
SC Urban Water Supply.
All the rest.
Submits that he has received the instructions and prays for 3 weeks time to file the counter affidavit. In view of above, the respondents shall file their counter affidavit on or before. When is this? Today is what, April? Nah? On or before
19 May, my lord.
28th of April 2026.
Yes,
With a copy to the other side.
yes. In the meantime.
So thereafter, the petitioner may file rejoinder affidavit if so advised within a period of 10 days.
Yes.
List the matter on
15.5.
15.5.
My lord, obliged.
On or before, I said, what did I say? 28 April.
28.
Since you have received instructions, so you should.
Other two matters are the same, my lord. Other two matters are same, my lord. The 35 and 36, same order will do, my lord.
You have received instructions?
Same one. Okay. But the parties are same.
Okay, you write Mr. S. Bora, Learned Counsel appearing for the
Same.
petitioner in WPC number 5084. Okay, you have to write that number. 5084 of 2025.
Oh, okay. My lord, obliged.
Then the other matters, who is appearing?
My lord, same party, my lord. I serve the copies also, my lord. And if required, I will serve the copy, my lord. Same party, same issue. Name may be issued.
No, this item was how much? 34.
34 order has been passed, my lord. Now,
This was item 34, which order was passed.
yes, and 35 and 36, my lord, same parties, my friend appears for the department, my lord.
Okay, you have to redo that case number, okay? Instead of, I said 5084, na? Cancel that. Instead of that, you write 6711 and 6807 of 2025. I repeat, 6711 and 6807 of 2025. Now, in respect of this item 34, what will do? What will happen? Will it cover the case?
The same case, my lord, same party, by different person, for, my lord, leave salary. Yes.
Next slide. In respect of WPC number 5084 of 2025, the name of Mr. S. Bora, Learned Counsel, Learned SC AR, Urban Water Supply and Sewerage be reflected in the cost list as well. Mr. Counsel for the petitioner, Mr. B.K. Das, shall furnish Mr. Bora a copy of the writ petition during the course of the day
Yes.
to enable him to obtain instructions. This would be a common order.
For filing the affidavit advertisement. Because same instruction will do. I have enclosed a, my lord, their office memorandum, there they say, we are entitled, but why they are not paying? That is the issue, my lord.
The respondent shall also file the
File
affidavit,
Yes.
deposition, and the
Well,
petitioner may file the joint affidavit as directed herein above in the other two writ petitions. Yes.
Pleadings are otherwise, pleadings are complete otherwise.
Parties are represented by the respective councils and they submit pleadings are complete and praise the matter for to be listed on for admission hearing on a convenient date. We have above list on 21/5 for admission hearing.
That can little bit earlier, lordship, actually, government has already issued fresh advertisements, so some urgency is there. Probably, lordship.
19/5.
38.
There was the order dated 18/3/2026. The petitioner is not represented by his counsel today as well. Mr. S.M.T. Chisti, Learned Standing Counsel, Elementary Education Department is others present. For ends of justice, list the matter after the Bihu vacation on a date to be fixed by the registry.
39.
But salary not received, that was the case, my lord. Grade 4 employee, my lord. Instruction was sought for, my lord.
Yes, Ms. Barua.
He is all along employee from the year 92, my lord.
What is this? What is written here?
The central government published the finance department was not attached to the patent, to which the removal will be done as a patent of silver. That's the rules 12A of the finance bill. And your lordship,
So this is a blame game. A will say B has not done this, B will say A has not done this. And C will suffer.
In that letter, it has been mentioned that the treasury officer has been insisting on submission of the financial side and conference for processing the failure. But the DDO was not submitted the conference.
Who appears for the DDO? Who is DDO? From the department only, DDO? Inspector?
But he has issued that letter.
Which letter?
Well, last occasion, I placed letter before your lords. Only because of the treasury officer, we are time and again sending.
It's already here, same letter. Miss R.M. Barua, please write down. Miss R.M. Barua, Lanet SC Finance Department, submits that the treasury officer has not received the documents that was required, which includes the concurrence of the finance department in terms of the provisions of Rule 12 bracket capital A bracket 3 of the Delegation of Financial Powers and Rules 2022. And therefore, in absence of any of such document being furnished by the DDO, bill could not be processed. What is this 12A3?
Your lordship, basically, last page, your lordship, as the conference in the finance department, right, where finance department of the lordship, engagement of master workers or any factory workers, any salary has to be taken for because, finance department option has to be taken. In point 7, your lordship shows sanction of allowing special pay on the overtime allowance unless covered under any specific operation by the finance department. The finance sanction is necessary at all.
What is the petitioner working as?
Lordship,
Petition is working as?
master or employee, my lord, a
Okay.
peon, my lord.
Okay.
Grade
Now,
4.
department, who's for the department? You, Sharma?
He was appointed 27/1/92. He was regularly drawing the salary, my lord. Subsequently, from the month of May 25, my lord, salary has been stopped. And he has also undertaken his signature, my lord, saying that, my lord, he need regularization. Earlier occasion, when he filed the petition, my lord, and then, my lord, he was directed to put his signature that my post cannot be regular, need not be regularized, and so I want to get my salary.
Mr. Yudas? You, Sharma? Mr. Sharma, what is to be done? Who was the DDO? Inspector of Schools. So DDO and Inspector of Schools are creating the problem.
He has issued the letter 2/4/26 saying that we have submitted all papers time and again, but it is the treasury officer, they are not releasing. This is tug of war, my lord. Last occasion I placed for it also. Therefore, it is clarified that salary of the petitioner has not been stopped from this.
Please write
office.
down. On the other hand, from the letter of the Inspector of Schools, GDC Golpara, written to the Director of Secondary Education, the Inspector of Schools has stated that the Treasury Officer Golpara has not been passing the wages bill of the petitioner. And that the Treasury Officer is insisting on submission of financial sanction and concurrence for processing the bill. Stop. So this is required, isn't it? Otherwise,
What's the amount?
earlier how it was disbursed then?
It was regularly he was drawing.
What do you think is the breakfast salary? Disbursement is given by the area salary, the finance salary is provided.
This is area salary.
Arrear as well as regular. From the month of May, it has been stopped without any reason.
Stop. However, the petitioner had been given his salary prior to month of May.
Yes, madam, from the year 1992.
Which May? This year? Which year?
From the year 1992,
May, no, May of which year?
25 up to May.
May of 2025.
He received up to April. From May 25, it is.
Okay, up to April 2025.
Yes.
To stop, therefore, some clarification and instructions is required to be obtained by the learned standing councils for the Secondary Education Department by the next date. Stop, Mr. U. Sharma, Learned Standing Council, Secondary Education Department, to obtain instructions accordingly. List the matter on
22, my lord, 22, my lord. 22-4. Salary, my lord, that is why.
salary.
Yes.
I don't know, but what is the position?
24.
Okay, on 24-4. Who is 5? Who is 5? Miss, your good name? I Datta. R Datta. Learned Council appears for the Accountant General Sam. Bracket respond number 5.
Hello. There's no one matter.
What is that? Call. You are for which party? This is item number.
There is a hearing matter, my lord.
Oh, hearing matter. Yes. After the vacation?
Short date may be given, my lord, is 2021.
On the request on
Petitioner was dismissed from service.
on the request of Miss, made on behalf of Miss A. Gayan, learned. She's what? CGC. CGC. Appearing for the Respondent Union of India. The matter stands adjourned to be listed again on so 21-4. Oh, hearing. All right. Okay, happy Bihu.